without giving us the opportunity on our side.
Well, one of the things that I noticed is that Miami Township does not really partner with the school district financially. So there's so much more that could be done, that the township should be partnering with the district and finding ways that they can help fund some of this stuff. Like the Mercy Health Flex in West Claremont. I mean, if it weren't for that, West Claremont would be bankrupt completely. So when we were meeting on the middle school, I brought that up. I said, why are we not going to the township and partnering with the Miranda complex? Well, the township could have used that complex for other things, so we could kick some money in to help pay for it. They don't. The neighborhood's going up, they could be tipping. Some of their tips on it, they don't do that.
All rise. The Court of Common Pleas for the County of Claremont in the state of Ohio is now convened with Judge Jerry McBride presiding. You may be seated. You are on the record.
So we have some preliminary matters, I believe, Mr.
Thank you, Your Honor. Your Honor, I did file a motion to withdraw as counsel on this matter this morning. Mr. Lehrman filed the motion for sanctions and the request for attorney's fees pro se. I asked the court to leave in order to withdraw so that he may be heard on his arguments.
Mr. Lehrman, do you have any objection to that?
Nope.
You are excused. Thank you. Any other preliminary matters? So I believe what we are here for today is your application, Mr. Lehrman, for attorney's fees and reasonable expenses under Civil Rule 11 and under revised code section 2323.51.
Yes, sir.
Is there anything else that you have today? You bring today?
Nothing new today.
Okay. And Mr. Thomas, anything you bring today for hearing?
Nothing against Mr. Lehrman.
Obviously, you're going to disagree with Mr. Lehrman.
Correct.
So is there any other matter that you have before the court? Okay. And are both sides ready to proceed?
Yes, sir. Yes.
So you are each, I assume, going to testify. Is anyone else going to testify?
No.
Would you swear in the witnesses then?
Could you both please rise and raise your right hand, please? Do you solemnly swear that the testimony you're about to give before this court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated.
The opening statement.
Yes, Your Honor. Good morning. Again, we're here today to discuss the motion I submitted on May the 13th of this year. This was my request for findings of frivolous conduct against Mr. Thomas and Rule 11 sanctions for the matter of the civil protection order hearing that he initiated. Recall, we were here in April, again, at Mr. Thomas's initiation and request for a civil protection order hearing, in which hours of this court's time was wasted grading through irrelevant witnesses, attempting to compel improper discovery, including from other officials and law enforcement in Claremont County. And truthfully, it was simply revealed that this whole matter is really an extenuation of his continued ongoing malicious, offensive, harassing conduct towards myself and my family. In the matter, again, third parties were compelled to attend improperly and had to retain their own counsel, and this again was just a huge waste of time and expense. Mr. Thomas submitted effective and improper subpoenas and motion filings. Again, complete waste of the court's time. And he submitted some of those items knowingly that they were defective and that they lacked any evidentiary support. Again, I'm here because he's continued that behavior in other filings and matters that the court is well aware of. This is simply a long-running campaign of personal animus and prejudice against myself and my family and the party of Mr. Thomas. So today, I'm simply seeking to be made whole for this undue expense that I've had to obtain counsel and defend myself against these blatant and harassing conduct and violations. And I respectfully ask the court, as my motion has been not responded to by Mr. Thomas, that it considers it unopposed and considers granting it here today, or that it's taken under advisement on its merits with whatever else will be here today. Thank you.
Mr. Thomas, do you wish to make any opening statement?
Yes, Your Honor. So, Your Honor, with this request for sanctions, Mr. Learman, on his own account, decided to hire an attorney to defend himself, but then chose not to take the stand to testify. Every witness
earlier this week. Again, I think I laid out the argument pretty clearly. There's established case law regarding what defines frivolous conduct and statute that defines frivolous conduct. It very clearly mirrors some of the conduct of Mr. Thomas's proceedings, which are irrelevant subpoenas and documentation used to harass witnesses. The behavior with which he entered into this, again, posting some of his inflammatory items online, advertising well that he's seeking to enter into these legal battles against me for the purpose of harassment. And again, I remind everybody that we are here at the invitation of Mr. Thomas. He claims people are seeking him out to hurt him, but he initiated the petition. He brought everyone and subpoenaed everyone to court. And it's at his invitation that we're here, and the waste of the court everyone's time that we're here. I respectfully ask to rest on my submitted items in my initial memorandum and the updated one from last week. Again, there's an ample amount of discrete evidence and case law that says these actions by Mr. Thomas are frivolous. They harm the dignity of the court, and that he continues to do this sort of perversion of legal conduct unsupervised, and they should absolutely be answered for.
Any evidence you wish to present? Do you have any additional evidence?
No additional evidence, right?
So, Your Honor, am I able to, are we at the point where I can ask questions to the witness, or are we not there yet?
Yeah, you can ask questions.
So, Mr. Lerman, did you create a page on Mr. Thomas called Change Claremont?
Objection, Your Honor. Again, Mr. Thomas is relitigating items that were closed and dismissed, which is the matter of the civil protection order hearing. We're here today for him to answer to my multiple pages, which were properly served upon him. He actually posted a picture of them on his website saying, "This is the dumbest submittal I've ever seen." Yet he has not legally answered or responded to my many claims against two filings. If he's unwilling to do that, again, I ask the court to consider them on their merits. We are not here to relitigate his potential claims, which were completely unfounded, as found by this court in its ruling, to be dismissed for civil protection.
Your Honor, I am merely establishing a baseline of, in his argument, he's saying that this is frivolous conduct and frivolous filing. I find that menacing by stalking, which we have recently discussed the criteria that meets, if Mr. Learman partook in that, then this would not be considered frivolous conduct. I believe that creating an entire page of somebody, taking their images of their kids, their family, their dead friends, and posting on it constitutes non-frivolous conduct.
Your Honor, it was determined by this court in your ruling that I did not engage in that conduct and no protection order was awarded to Mr. Thomas. He was completely dismissed. He is attempting to relitigate settled matters.
You can ask questions. Go ahead.
So, Mr. Learman, did you or did you not create an entire page dedicated to Mr. Thomas and his affiliates in order to harass and make fun of him for several months? Yes or no?
I completely disagree with the premise of your statement. He's not able to make specific statements. He's interfered and interjected in their purpose or intent. Again, he's relitigating past
I
matters.
disagree, you simply indicate that.
Yes, I object to the statement for relevance and disagree.
Can I ask for a direct answer, Your Honor, unless you're sustaining his objection?
What's your answer to the question?
Can you please restate your question specifically without adding
Did you create,
unnecessary opinion?
did you create a page, Facebook social media page called Changed Claremont and dedicated to Mr. Thomas and his affiliates to harass and make fun of them?
I created a page called Change Claremont. I completely rebut and disagree with any extra opinion that is your question.
So you did not intend to harass or make fun of Mr.
Your
Thomas?
question's been answered.
I'm asking you a second question. Your intent in creating that page was not to harass, stalk, or menace Mr. Thomas? Myself.
That's correct, and it's been settled by the court, Mr. Thomas.
Your Honor, I would like to present as testimony that Mr. Learman has filed 2 protection orders against me in the past. The first one
Do you
was,
have any more questions for Mr. Larry?
oh, I'm sorry. I do, Your Honor. Mr. Learman, have you worked with Brittany Thomason on her current case?
I object to relevance. I don't understand why he's asking about other parallel cases. We're here to talk about his frivolous conduct.
It goes into the
His
harassment.
specific initiated matter, his CBP 386 protection order request.
Let me hear your question again.
I asked, Your Honor, I'm asking Mr. Learman, did you participate in the filing of the protection order against Mr. Thomas with Brittany Thomason? Because you've referred to that in your filing paperwork on this case, right here. I'm asking him, did he participate in that case? Because there's information in here that he wouldn't have had if he wasn't present for that, or he's calling out things that happened in the trial. And I want to know, did he conspire with Ms. Thomason to file a protection order against me? That would be, again, considered harassing and stalking behavior.
Outside the scope of this hearing, Your Honor.
It's outside the scope of this hearing.
Okay.
Just saying.
So I will, Your Honor, I'll move to testimony for myself whenever you're ready.
Okay, go ahead.
So, Mr. Learman has filed 2 protection orders upon me in the past. He has seeked me out online. This all started with political banter on a Cincinnati Enquirer page. That's how this originally started. He hates Donald Trump. It's his personal right. He's allowed to do that. But he seeked me out on a Cincinnati Enquirer public page and made a statement, aren't you the guy that beat your kids? That's how this all started. And then we got into it back and forth, and it went on for probably a while. But then he sent me a picture of my daughter and her Facebook. And I warned him, now you're crossing lines here. Do not mess with my kids. When you start messing with my kids, this wasn't something that was posted publicly We're not sure how he got it, but that's when it turned sour, really sour between us. It started with just political banter, but then it got to be, when you take a picture of somebody's kid and send it to them, that changes the pace. It's no different. This idea that Mr. Lehrman is instigating this behavior with me, all the witnesses that came in through the trial to testify, yes, he did, yes, he did, yes, he did. I've gotten 2 letters personally sent to me by Mr. Lehrman through U.S. mail in the last 2 weeks. I've asked the police department to inform him I do not want contact. I've blocked him.
Brief objection, Your Honor. I'm serving copies of legal motions as required by local court rule to Mr. Thomas. And for him to interpret that as harassing uncontacted, unwanted behavior is again simply an astounding lack of knowledge of the law. And again, that's why we're here.
So I've gotten 2 letters unwarranted. They're not certified mail. They're just handwritten with a stamp, nothing certified from him. I have blocked him on social media. He has never blocked me on social media. Why? Because Mr. Lehrman wants to instigate, then victimize. So I finally got to the point after all the stuff that was going on, I blocked him on social media. He still continues to come under false accounts to read my stuff. He has screenshots of it. I have proof of that, where he's taken screenshots and sent it to Ms. Thomason. And a comment to Ms. Thomason, Bill Thomas is a piece of shit who beats his kid, is a wannabe MAGA political activist. This was a message he sent to Ms. Thomason. It's not, the idea that this is frivolous conduct and I should be sanctioned because I felt harassed and threatened by this individual who has filed 2 frivolous CPOs on his own. And then, Your Honor, I would like to present into evidence today, if I may approach. May I approach?
Yes.
I understand and I'll respect the court's decision that a protection order was not awarded, but the Claremont County Prosecutor's Office has determined that Mr. Lehrman's conduct has exceeded telecommunications harassment, and he is being, I am testifying as a defendant and a witness to a grand jury against his actions against me. He's been investigated by the Sheriff's Department, has been submitted to the prosecutor's office, and I will be testifying next week to a grand jury. Whether they indict or not, I don't know. But what I do know is the prosecutor's office deemed it necessary to take it to this level. So while I respect the court's decision,
Your Honor, does the other party have a copy of this evidence for
This
myself?
is just a grand jury.
Thank you.
while I understand that the court's decision, I'll respect your decision not to warn the CPO. But the conduct of Mr. Lehrman obviously has turned criminal for him to be part of a grand jury where I have to go testify to a grand jury next week. So I respectfully would disagree to this motion for sanctions because his conduct is certainly not unwarranted. It certainly rises the line of harassment, and it's definitely not frivolous. The CPO was filed in a very serious manner to protect myself and my children from things like what we're experiencing now, where Mr. Lehrman has teamed up with somebody to file a protection order. He saw a conflict between me and another individual. I have pages of communications that lady has shared between he and her, where Mr. Lehrman, like I said, Bill Thomas is a piece of shit who beats his kids, is a wannabe MAGA political activist. That is instigating and harassing. I don't beat my kids, never beat my kids. It's defamatory, and I've just not taken the time to sue him. But I 100% object and disagree with this motion filing, and I'll rest on that, Your Honor.
Right.
Sure, Your Honor. Again, everything that Mr. Thomas said here, again, it's not supported by any evidence. There's been significant filings with my specifically stated explicit argument and facts. He's chosen not to respond to any of them. He continues to reiterate these completely false claims that have been debunked and in fact are debunked in my previous filings regarding totally untrue, stalking of his daughter and other things. He brings in these irrelevant other parties and their actions, assuming there's this grand conspiracy against him. I think the common denominator to all this is simply William Thomas. It's no secret that he makes himself out to be a public figure online, a polarizing public figure, certainly. And when he decides to go after and attack people, they also have a right to pursue legal options to defend themselves. I was not a party to this other CPO that he mentions, and yet Bill Thomas, for completely inappropriate reasons, sought to compel me to become a part of that action, which I successfully quashed my subpoena. It's irrelevant, was defective, and improper. But for him to sit here and say that his actions were somehow warranted based on a belief in his mind that he's being persecuted is completely untrue. And again, he's not chosen to respond to any of the items in my motion filings that clearly establish and demonstrate in parallel with established case law in the state of Ohio. His specific actions were frivolous and they merit some response.
Can you respond?
Yes, Your Honor, if I may approach, I'll submit these to the court. These are communications between Ms. Thomas and Mr. Lehrman.
And I ask that you keep any copies as well, Your Honor, if they'll be submitted or spoken about.
It's just copies of your conversations that you have in your phone. He has copies of those, Your Honor, because they're in his phone. Those are screenshots that were sent by Ms. Thomason of all the communications. Mr. Lehrman saying he has no interest in that protection order. I find it odd that he had all these communications with her talking about me, and then she files a CPO shortly after that. So I just, again, I think we're here, we're going back and forth. The bottom line is this. He participated in harassing conduct. I filed a protection order under the grounds of what I felt was menacing by stalking. You decided that it wasn't. Fair enough. Prosecutor's office has now filed criminal charge.
I decided there was no basis for it.
Correct, you're right, and I'll respect that decision, Your Honor. But the prosecutor's office felt that maybe these actions are criminal, so they've taken the steps to take it to the further.
Your Honor, I object to that characterization completely. In fact, there's emails to the both of us from the prosecutor's office saying they don't want to be involved in this type of behavior from Mr. Thomas. They've elected to hold a grand jury for us to give our cross complaints against each other, which is occurring next week. Any characterization that the prosecutor's office is quote, pursuing charges or hinting that any behavior to become criminal is absolutely unfounded in law, and there's no basis for that before we have the upcoming grand jury, which has been again recused from the prosecutor's office.
Yeah, I don't think either of you can speak for the prosecutor's
I
office.
completely agree.
Your Honor, I just asked for you to, what I submitted to you is straight from the prosecutor's office.
That you're subpoenaed to appear.
Correct, that's
It's
all I'm
completely
saying here.
irrelevant.
What happens from there, I don't know. I'm just saying that I've been asked to be a witness to a grand jury. I don't know anything past that. So I asked the court, take these facts into account and dismiss this claim that I need to reimburse Mr. Lehrman for actions that he's committed and sought after, and now he's trying to victimize himself as a victim in a matter that he himself has been an aggressor on.
Recall, Mr. Thomas, we're here at your invitation, at your petition, at your request. Nothing was initiated in this matter, the matter we're here for, 386.
Based
I'm
on
not
your
here
actions.
voluntarily, I'm here because you compelled me here by a false filing that is completely frivolous.
You're here because your actions brought you here. That's why you're here. And if you need to block people or at least stay off social media and leave people alone, and then you won't be coming to court anymore. Your Honor, I've taken your advice from the last hearing. I'm done with that, with these people. There will be no more of this nonsense because I've hit my limit. I don't have time to come down here. So I've taken your advice to move on and let things go. Mr. Lehrman has not. So I'm trying to do that, take your advice from your last hearing and to let things go and move on. But I can't as long as I keep getting letters in the mail, contacts from him. I don't want contact with him. I'm not going to write about him anymore. I'm not going to bother him anymore. I'm done with it. This kind of nonsense, sending me these letters in the mail with, respondent, whatever he sent to the court. Enough's enough.
If there's nothing else, I will rule based on the record.
All right, one final item. I'd just like to submit, I do have a copy for the other party as is required by rule. This is simply a short motion and exhibit that describes the specific amount of the costs that I'm seeking. So I'd ask you to, if you can include that in the record for you to take under advisement.
Okay. And make sure you get a copy to Mr. Thomas.
Your Honor, for the record, this is the first time I'm seeing this. This was not filed with
Take
the
time,
session.
take time.
As I just did.
We're in no hurry, I just want to hear everything you have to say about it.
Sure. Your Honor, I don't know who John Griner is for $1,529. As far as I know, Jesse Taylor was Mr. Learman's attorney. So it seems to me that Mr. Learman was contacting people, asking questions, is asking reimbursement possibly for that. I don't know, but it looks,
Clearly stated.
What he is saying is these expenses, these costs were incurred as a result of your actions. That's what he's saying.
yeah.
And so to the extent that you disagree with that, I need to know your disagreement and why you feel that he's incorrect.
Well, Your Honor, I disagree with all of it because I don't believe it should be my responsibility to defend Mr. Learman on his actions. But second to that, there are fees in here that, in my opinion, looks like he had this reviewed by other law firms. I don't know. I just know Jesse James Taylor was his attorney. So the last invoice seems to me like it'd be the only one permitted to be submitted, but that's up to the board. So I would object to everything except that being submitted, other than what was handled by his actual attorney.
And so I understand the expenses that you claim were caused by Mr. Learman, or Mr. Thomas, excuse me. Fruki, ELL, what was that?
Yes, that was Attorney Jack Griner, and I spoke to him multiple times regarding the civil protection orders that were back and forth between Bill Thomas and myself. He and I eventually parted ways to appear in person. I selected attorney Jesse Taylor. He and I had multiple discussions back and forth regarding the filing of the upcoming civil protection orders between Mr. Thomas and myself.
So, Your Honor, if I understand that correctly, please correct me if I'm wrong, you said civil protection orders going back and forth between me and Mr. Thomas. That would imply that you're trying to tie expenses from previous cases with these legal fees to this case, because there's only one protection order filed in this case. So, Your Honor, again, I go to this and say, I have no idea. He's filed 2 protection orders against me. I have no idea what legal fees are pertaining to this case versus him seeking legal advice for his own protection orders that he filed against me, which would absolutely be irrelevant to this case.
What he's saying, I believe, is that the expenses that he incurred were caused by you. They should not have been incurred. For instance, the representation by counsel. He's saying that his need to talk to Mr. Griner was as a result of your filing your civil protection order, which of course you did.
If you go back and listen to this, Your Honor, you'll hear what Mr. Litterman actually said was, Mr. Griner, I spoke to him on multiple occasions to talk to him about the CPOs between Mr. Thomas and I.
Correct, which includes the one that you also filed.
Right, but you filed. If there's time for petitions that he has filed against me, I don't feel that ties into this case. This has a specific case number. If these legal fees are pertaining to another case number, they're irrelevant and they should not be seeking, he should have sought sanctions on that case number. What I'm saying is he's tying in protection orders that he filed against me. he's tying some of those legal fees into this document, that legal time. That's what I'm saying, Your Honor.
Reasonable and related fees due to the conduct of Mr. Thomas.
So these are on a different case number. I'm not sure why they're submitted on this case number.
What's your explanation for that?
As I stated, Your Honor, I spoke to that specific attorney, that firm, Jack Runner, in relation to CPOs, both the one initiated by Mr. Thomas against myself and the one of which I was advised by him to drop against him, against Mr. Thomas, with the thought that he would calm his behavior. And clearly that didn't happen. We continued, and that's where we are today. Again, Your Honor, he's already made an objection to everything that I've submitted. I suggest it's all taken under advisement. And again, I want to remind the court that he's not responded to any of the specific statements of fact I've heard in my 2 motions for frivolous conduct on this matter. He simply refused to respond to the court.
If you're done, I will take this under advisement and move on.
All right, thank you, Your Honor.
Thank you, Your Honor.
I think it's record for this guy. Thank you very much.
All rise. Court is adjourned. If you guys don't mind leaving separately.
Yeah, I'll
we
let
do-
him go.
Yes,
It's fine.
please. We normally try to keep the parties separate.
A week, 2 weeks. No, it's always taken under advisement. Usually, unless it's a slam dunk.
Okay.
Mitchell's case, but what it was. All right, I'm getting out of here.
You got it.